According to the law, jurors are supposed to follow jury instructions. Do they? Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. As I said, according to the law, jurors are supposed to follow the jury instructions in order to reach a verdict. In practical fact, post verdict interviews often show that the jury did not follow the judge's explicit instructions, but instead used simple common sense, and in many respects, that's exactly what we hope and expect juries will do. We expect them to use their brains and not be led around by the nose to a verdict that someone else desires. So I think it's important to give the jury some general guidance, but not necessarily to tie their hands. But by the same token, you have to give them guidance. In Karen Reed's case, the jury instructions for second degree murder are not necessarily long, but they are needlessly complicated in that they do not provide good guidance for the jury in terms of reaching a verdict. Let's take a look at the jury instructions for Karen Reed. Now, this is the Commonwealth's request for jury instructions, and it says in this case, Karen Reed is charged with second degree murder in violation of the statute and while operating a motor vehicle under the influence of liquor. And now comes the Commonwealth and respectfully requests the Honorable Court to instruct the jury as follows. And they're using the murder in the second degree criminal charge. In order to prove murder in the second degree, the Commonwealth must prove the following elements. The defendant caused the death of John O'Keefe, the defendant intended to kill John O'Keefe, or the defendant intended to cause grievous bodily harm to John O'Keefe, or the defendant intended to do an act in which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these three requirements in more detail. The first element is that the detail caused the death of John O'Keefe. A defendant's act is the cause of death where the act in the natural and continuous sequence results in death and without which death would not have occurred. Well, that's a distinction here or a definition that doesn't really help you. It's like you understand what causing someone's death is. They killed them. And in this case, it was a result of a skull fracture is what caused the man's death. The second element is that the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe or intended to do an act in which the circumstances known to the defendant, a reasonable person would have known, created a plain and strong likelihood that death would result. As you can see, this second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill, the second is that she intended to cause grievous bodily harm, and the third is that she intended to do an act which she should have known would have killed him. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine whether the defendant herself actually knew about the relevant circumstances at the time she acted. Then you should determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act in which the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. You see how they keep repeating the same language. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of those elements beyond a reasonable doubt, you must return a verdict of not guilty. Well, that seems somewhat straightforward, doesn't it? But it's not straightforward. The reason I say they are complicated is that they do not provide any basis upon which to reach a verdict from a factual point of view. In essence, they allow the jury to roam freely through the evidence until they satisfy themselves that either the defendant committed the crime or that the defendant did not commit the crime. They don't give any guidance as to what acts the state has charged her with or believes caused the death. Now, on the second degree murder, there are two potential causes of death. One is the skull fracture, and the other is the hypothermia that contributed to it. I don't think they can find her guilty on the basis of hypothermia alone, but here again, there's no way for them to distinguish if they decide he died from hypothermia because the Dr. Scortibello, the medical examiner, said that. Well, then even though she didn't list that as the primary cause of death, that would satisfy. And that would be wrong because hypothermia alone did not kill the man. He had a skull fracture and it pushed the base of his brain through the foramen magnum. And that was the cause of his death. That's pretty obvious. But in this regard, these instructions could, under these instructions, a jury could determine that Karen Reed used cosmic rays to kill John O'Keefe because it doesn't link any act or omission of the defendant to the particular crime. While it definitely discusses the elements of the crime, it doesn't provide the jury with any information about the Commonwealth's theory. Consider the first element of the jury instruction: the defendant caused the death of John O'Keefe. How? When? They don't even tether it to a date. How? When? Why? None of that is given. Now you might think that's a good thing. You're not, leading them around by the nose, but it really is not. In Missouri, we would call this instruction a roving commission because it does just that. It allows the jury to roam freely through the evidence to find facts that they believe caused the death, and they're not tethered to the evidence the way that they should be. And that's not the way to convict the defendant. These are good instructions for the prosecutors because they don't have to talk about the evidence nearly as much at the end of the trial. They just have to say, well, we proved she killed him. And that's pretty much what Brennan did. Anyway, this jury instruction is not a good jury instruction because it doesn't give them any kind of factual guidance as to where they're going. Now, let me show you the way this is done in Missouri. This is taken from a presentation by one of the public defenders, and it illustrates how a jury should be charged in Missouri for second-degree murder, which is very similar in most respects to how second-degree murder is defined in Massachusetts. As to count one, if you do not find the defendant guilty of murder in the first degree, you must consider whether he's guilty of murder in the second degree. There is a similar pattern to that in the Massachusetts rules. As to count whatever this is, I believe it's count one, if you find and believe from the evidence beyond a reasonable doubt, first, that on January 29th, 2022, in the state of, in this case it would be Massachusetts, but using the Missouri instruction, in the state of Missouri, the defendant caused the death of John O'Keefe by, and here you have to briefly describe the means by which death was caused. They say shooting, stabbing, striking, whatever. Here you would put hitting him with a vehicle driven in reverse, something to that effect. Because it was the vehicle strike that they claim killed him. And it wasn't the hypothermia that resulted from him being knocked out. The judge has a duty to ensure that the instructions in Missouri conform to the evidence. So if you tried to get in hypothermia in here, you could probably get it in as contributing to cause, but not actually causing the death. Particularly under the evidence as it was adduced at trial, it was the skull fracture that resulted in immediate incapacitation and death. So that's what would go here. Being struck by a vehicle, and second, You have to insert one or more of the following, and you can submit them in the disjunctive. So you can do it either or. One, the defendant knew or defendant was aware that his conduct was causing, if it is a series of acts, or was practically certain to cause the death of John O'Keefe. Two, that the defendant's purpose, and essentially purpose is used here as intent, that it was the defendant's purpose to cause the death of John O'Keefe, or three, that it was the defendant's purpose to cause serious physical injury to or cause the death of John O'Keefe. And third, that the defendant did not do so under the influence of sudden passion arising from adequate cause. That's unique to Missouri. If you find those things, then you will find the defendant guilty under count one of murder in the second degree. However, unless you find and believe from the evidence beyond a reasonable doubt each and all of these propositions, you must find the defendant not guilty of murder in the second degree under this instruction, but you must then consider whether he's guilty of murder in the second degree under instruction number whatever else, particularly if you're doing something like felony murder. You can see where here, if you think about it, this would have been a much better instruction because it would have given the jury something to tether its verdict to. And that's important because if you look at those instructions, how careful the court is to instruct on the theory of the case. In other words, if the prosecution presents a theory that someone was shot, that means that the individual's death was caused. It seems fairly simple when you can read this instruction. A juror knows exactly what he has to find in order to find somebody guilty under the law. If you just say he caused the death, then, you know, maybe it wasn't the gunshot. Maybe it was the negligence of the medics when they came and picked the guy up. And I've seen that argued in cases. So it's really important when you instruct a jury to instruct them properly. And that's because due process really hinges on the ability of the state to set out the charges, give ample notice of the charges, give ample notice of their theories, and work off of those theories at trial, and then convict off of those theories in the verdict phase. If they don't provide adequate factual guidance, then like I said, the jury could find that Karen Reed killed him with cosmic rays, or if you remember that old movie from probably 50 years ago called Scanners, where these guys use their minds to make people's heads blow up, um, crazy movie, let me assure you. Uh, that would be one of the things that they could, essentially come to that conclusion. They could all sit around the table and say, well, yeah, you know what? Cosmic rays will work. We could do that. It's a really screwy way to charge a jury because it doesn't give them the facts. It doesn't give them the theory of the case. It just gives them the elements of the crime. And of course, you can certainly argue that the defense gives their theory of the case and the prosecution gives their theory. I get that. But that's not coming from the court. It's not an instruction. That's argument. An argument, while it can be powerful, it is not the instruction. It's not a laying out of the law, which is what these instructions are supposed to be. So tell me what you think. Tell me what you think about the instructions. Tell me what you think about the difference between Missouri's instruction and Massachusetts' instruction, and which instruction set is better. And feel free to disagree with me, because obviously I have a bias in Missouri because I like the way our instructions are written. This mimics in most ways the way our civil instructions are written for things like wrongful death. So it's a good way to go about doing this, and I think the right way. And I think it meets the constitutional tests also. Let me know what you think. Drop me a comment or an email. Tell me what you think.
That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.